It's not the first time that she has not agreed to come to the summons. It's leaving dad on the hook to say, hey, am I really the child's father? Okay, so nevertheless, I think it's a bad set of circumstances when you are telling a man that he is the father of that child and you refuse to help the dad to establish paternity. Nevertheless, let's dive into the video. Let's get a better understanding of what I'm referencing, and then you leave it in the comments. Before I play this video, please subscribe to this channel. We on the road to 6,000. We almost halfway there. So nevertheless, let's go ahead and rock and roll.
She don't like white people, which is weird that she would even have sex with me. I don't know. It's really stressing me out. Like,
Ashley Rocket versus Sean Wright.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the front of the court's motion for entry of order for genetic testing. Mr. Magnuson.
Thank you, Your Honor. The motion is pretty self-explanatory. I don't believe I need to go any further into it. Genetic testing was requested in this paternity action. We scheduled it actually several times. At this point in time, plaintiff has failed to contact us or cooperate, so we're asking for an order that we can enforce to effectuate this testing.
Okay, thank you. Mr. Wright, is there anything you would like to add?
No, I know I spoke to Miss Rocket previously, and she already said that, which is weird to me that she's not trying to press child support or anything. I don't know if I think it's kind of basically like, I'm just going to say this as clear as possible from what I get. Yes, she's black, and yes, I'm white, and I'm not going to lie to you. She don't like white people, which is weird that she would even have sex with me. But at the end of the day, like, I'm kind of worried about my daughter because I've heard her say things to other people about not liking the baby because the baby's white. And I don't know, it's really stressing me out. Like, okay. I just don't understand her at all. Like, I've texted her myself probably 100 times with no response.
Okay. Well, sir, what happens is we'll get an order in place, and then we can deal with some of these other issues at that time. But we have to get an order in place for genetic testing. The court will grant the motion for genetic testing. Mr. Magnuson, would you put in the order that the plaintiff has to comply within 30 days of the date of the order?
Very good, Your Honor.
Okay. And I did have, I'll say as well, Mr. Magnuson, just for future reference, because I do note you have a few of these today. Court had one of these before where we could not get cooperation after the order was entered. And so what the court eventually did is the court suspended all the public benefits until such time as the person cooperated, and we got immediate attention to the case.
I would say that's probably what's going to have to happen with this lady.
Yep. Okay.
Okay.
Thank you. Thank you, Mr. Wright. You're free to go. Have a good day.
All right. Thank you. You too.
Thank you.
Rose versus Stephen Carucci Sr.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's motion to set aside default and default judgment. Mr. Carucci.
Yes, sir.
Go ahead. Go ahead with your motion.
Yeah, I just want to set aside the default because I really just want a DNA test. I don't even think the kid is mine. That's the main thing.
Okay.
I have 6 other children, and I pretty much know.
Okay. Mr. Magnuson, any response?
Well, just from a purely legal standpoint, Your Honor, I know the court's familiar with the procedural history of this case. Everything was done appropriately as far as obtaining the default. Service of process in this case was done by alternate service per the court's order. We noticed the matter for a hearing. Defendant failed to appear at that. So I would say procedurally everything was done correctly. So I think bottom line, my position is that the default should not be set aside and that the order should remain in place. Now, that being said, if the court were to order genetic testing, I would not contest that or put up any opposition to that.
Okay, thank you. Ms. Rose, any response you have? Ms. Rose, any response?
No.
Okay. Well, what the court will do is I'm gonna reserve on the motion to set aside. What I will do, Mr. Carucci, I will grant the order for genetic testing, so you can be in touch with Mr. Magnuson at the front of the court's office. He will set up the testing, and then we can do the testing, because if the testing comes back positive, then there's no reason to set aside the default or any of that. So what we'll do is we'll just reserve on that, and then proceed based upon what the test is. Okay, anything else?
So the court is ordering genetic testing at this time?
Yes, correct.
Very good, Your Honor.
And Mr. Magnuson, you can handle that through your office, and then we'll.
And you have Attorney Magnuson.
Very good.
Yeah, if you could, Mr. Magnuson, if you'd prepare that order for genetic testing, we make sure we get it correct.
Yes, Your Honor.
Okay. Okay, then you'll be notified of when you have to appear and when we're going to have the testing done, and then we'll get the results, and then we'll be able to determine how if we proceed further. Okay?
Thank you, Your Honor.
Thank you. Don't interrupt.
So you can understand me better.
Sir?
Roy Clark versus Amia Watson.
Court will note the appearance of Ms. Podolsky on behalf of the defendant. This matter is before the court on the plaintiff's motion for 50-50 custody. Mr. Clark, you state in your motion, and I quote, "I want 50-50 custody," end quote. You've not put anything else in the motion. Is that accurate?
I didn't know I was supposed to put anything else. I thought you told me to go with my motion. My first motion. That was the first motion I was going with.
Okay. Well, the court notes that there was a temporary order entered back on March 14, 2024. Ms. Podolsky has stated that you've not asserted any proper cause or change in circumstances for the court to entertain setting aside the temporary order, which is accurate. You have a right, because we're still in the course of these proceedings, you have a right to dispute custody, but you do not provide any basis in the motion for the court to change the temporary order. What would
As
be
in what?
what?
As in what?
Well, as in, I can't give you legal advice, sir. When you represent
No, I
yourself,
don't want legal
you
advice.
have to file the proper pleadings, and
I
you
thought
haven't
that was
done
the
it.
proper way.
Excuse me?
I'm confused. I thought this was the proper way.
Well, you have to
This is the
file a
first
motion,
motion.
yeah, filing a motion, but there's things that have to be in the motion for the court to entertain your motion. And you haven't. Just saying what you want isn't a basis for the court to grant it.
Saying I want 50-50 custody is not enough.
That is not enough, sir.
So what? I'm confused. What am I supposed to put on the paper? Do you want me to say full custody?
No. What I'm saying is that if you file a motion, you have to set forth the basis for the motion. And
I'm sorry,
the
I don't know
basis
the
for a
basis.
motion
I don't know
isn't that
what
you
you're
just
speaking on.
want what you want. The law requires that things be in motions. In this case, there's a case called Babarka versus Grassmeyer, and it says that if you're going to change custody, you have to show proper cause or change in circumstances, which you haven't even alleged in your motion.
Sir, how can I change the circumstances if I was never? I thought you granted her full custody because y'all claim I didn't show up to court.
On
I
a
thought I
temporary
proved all that.
basis. It's a temporary order, sir. You still
Right,
have the
right.
right, you
So
still have the
my-
right to, sir, don't interrupt me. I'm trying to tell you what you need to do. I can if you're
I'm
gonna,
confused. I'm trying to get up. I'm trying
don't
to get out my
interrupt,
senses so you can understand me better.
sir. Don't interrupt.
All right, I'm confused, bro.
Well, you are. I'm saying there's a temporary order. You have a right to contest custody as the case proceeds by filing the proper pleadings in the case. Okay?
How do
Not-
I file the
Okay.
proper pleading?
Well, you're gonna have to get legal advice then, sir. You'll have to contact an attorney, get some legal advice or something, because it doesn't sound like you're able to do it on your own. So there is no basis to set aside the temporary order. So the court will deny the motion at this particular time. Ms. Podolsky, you can submit an order denying the motion under 7-day.
Thank you.
Okay,
Okay. This dude is more hard-headed than titanium brick. He kept telling him to not interrupt. And then he kept telling him he cannot give you legal advice. The first dude had relations with a woman who wants nothing to do with him. And the second dude, or the second plaintiff, say, hey, that's not my kid. Mama so shook, she don't even know who the father is in the first place. That's why she was so calm, because she knew who the father was. She would have said, you are the father. She didn't say that because she's confused on who is the father. So nonetheless, put it in the comment. How do you feel about this? 3 different trials, 3 different outcomes. We will see you in the next video. We're on the road to 6,000, so make sure you subscribe, and we'll see you in the next video.